Legal dictation exercise 97 start. Mr. Chaudhary submitted that as per the arbitration agreement, matter was referred to the arbitrator and the respondents contested the alleged claim of the petitioner, and after considering the evidence on record and respective contentions as well as submissions of both parties, the arbitrator made the award dated 31st December, 2009, inter alia, holding that there was accord and satisfaction and the contract accord was not induced by any duress or coercion, and as such no interference with the settlement agreement dated 5th February, 2004 was called for. Full stop. Mr. Chaudhary also submitted that the three cases relied upon by the petitioner for the proposition that whether the accord and satisfaction is vitiated by coercion or whether the allegation of coercion is an afterthought the required to be determined by the arbitrator, but in the instant case the arbitrator have gone into the factual background and upon considering the evidence on record as well as submissions made on behalf of the both sides, has come to a definite conclusion that the contract of accord was not induced by any duress or coercion. Full stop. The arbitrator also concluded that as per the original bill dated 11th September, 2002, the petitioner was paid by the respondents and the petitioner has received such payment unconditionally without any protest and oblique or prejudice, and has raised the alleged plea of duress and coercion subsequently after receiving the payment in full and final settlement. Full stop. Para. Mr. Chaudhary further submitted that recording of accord and satisfaction is lawful and valid by settlement of all claims excluding work contract tax and commissioning charges. Full stop. The arbitrator thus gave an nil award but recorded that the respondent was bound to pay the balance work contract tax if any payable and 1% commissioning charges if commissioning at all takes place, Mr. Chaudhary have cited a decision which is reported in AIR 1981 Calcutta 1995 in Union of India versus DK Boss. Full stop. In that case, the division bench of Calcutta High Court, after considering Section 63 of the Indian Contract Act, has clearly opined that the question as to whether the claim of the respondent stood discharged by accord and satisfaction was a question of fact and a dispute well within the ambit of arbitration clause, and the arbitrator decided the said question. Full stop. Accordingly, it was submitted that in the instant case also the arbitrator has gone into the dispute and decided that there is contract of accord, and as such there is no scope to raise any grievance against the award published by the learned arbitrator. Full stop. It has also been held that there was no substance in the allegation that the claimant was forced to sign the no claim certificate, being a finding of fact, which is not perversed and ought not to have been looked into by this court, which would appear from paragraph 8 of the judgment. Full stop. According to him, no case of perversity of finding of the arbitrator has been made out in the instant case by the petitioner, and therefore, this application is liable to be rejected. Full stop. Para. I have heard the learned counsel of both parties, and considering the submissions made by them as well as the materials available on record, including the award passed by the sole arbitrator on 31st December, 2009, full stop. I find that it was a contract for firm price without any escalation clause, full stop. It appears from clause 32 to the terms and conditions that for completion of the entire project under this contract, if any additional jobs are involved, the same shall be carried out at no extra cost, full stop. It also appears from clause 14.3 of the salient terms and conditions that final measurement certificate bill shall be prepared by the representative of IOCL and the contractors within 1 month from the completion of the work, and if there shall be any dispute for the terms of work, then IOCL shall be entitled to withhold the entire balance payment, and the contractors shall submit a list of disputed items from the final measurement certificate is prepared and signed by the contractors. Full stop.